of the Commonwealth versus Brian Walshe, criminal indictment 2023-0091. Matter continues on jury trial. Counsel's present in court. Counsel starting with the Commonwealth. Kindly identify yourselves once again for the court and the record.
Good morning, Your Honor. Greg Connor for the Commonwealth.
Good morning, counsel.
Good morning, Your Honor. Ann Yas for the Commonwealth.
Good morning.
Good morning, Your Honor. Tracy Cusick for the Commonwealth.
Good morning.
Good morning, Your Honor. Good morning, everyone. Kelly Portis on behalf of Mr. Walshe.
Good morning.
Good morning, Your Honor. Larry Tipton for Mr. Walshe.
Good morning. We'll wait for Mr. Walshe, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference. I don't know how many copies that is, but I think it might be enough. If we need more, I have more. I just put that to the side, counsel, until we get there.
You're making sure. Oh, thank you.
All right. Good morning, Mr. Walshe. I said good morning to everybody else, so good morning to you, too.
Good morning. Thank you.
So since the version that I sent you at 1:55 p.m., I've made the following edits, either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19, so what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of full page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page old page, now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you, and I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. it seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on it this morning, Your Honor.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office, so they may have the strapping mechanisms. But as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it or preferably strapped down to a hard board, it seems to me that that would be a good approach. Anybody object to that?
No, Your Honor. We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
Uh,
All right.
We don't have any objection.
So I passed out to you two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. Take a look at that and let me know when you've finished looking at them and have an opinion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine.
suitable.
Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spent a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I'd ask the court to read that.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
All right. Both are correct recitations of the law, so if you wish to draw from any of them, they're all good. And I'm not sure that they make a huge difference. All right. Any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover, the plural version.
The 4-person?
I have page 12, reaching a verdict, the third paragraph for each charge.
For the charge, yep.
And then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay.
In the next paragraph,
And same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I'll just end it at not guilty.
Your Honor, on page 13, role of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is. I made that change later in the day, too, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Although now I think most of the previous exceptions you made have been removed.
Just being cautious.
But I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a all to have a copy so that you can follow along while I'm doing it. It shouldn't take me very long.
All right.
You are unmuted.
Listen on session, turn your cell phones, please.
Everyone all set? Good.
All rise. Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do for the Honorable Justice Diane Frenier, Justice of the Norfolk Superior Court,
Ron here, give your attendance and you shall be heard. Let's have a call of the Massachusetts in this honorable court. Please be seated. Please turn off your cell phones.
Jurors, and welcome back to Northern House. Jurors, will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
Are we able to comply with my order that you not speak to anyone about this case?
Yes.
And do you all still have open minds?
Yes.
Those 4 answers, for the record, all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then, depending on how you're doing, given the time that's passed since then, we may have a short break, a bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately break it into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you caught me many times looking over at you. You've been paying attention. and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walshe. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walshe is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important, and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge, the jury instructions, in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walshe is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walshe to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walshe committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walshe does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walshe does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walshe beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walshe's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walshe guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So, the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walshe is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used in probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walshe is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walshe is guilty. I will explain these legal rules to you now. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous, that is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt this theory of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully caused Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. A defendant's act is the cause of death, where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walshe. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walshe. Second, that the defendant A, intended to kill Anna Walshe, or B, intended to cause grievous bodily harm to Anna Walshe, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walshe. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has 3 sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the 3 prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walshe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. Let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on 2 theories of homicide in this case, murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Do either counsel need to see me?
No, Your Honor.
Be happy to see you. I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up and, as I said to you before, shake a leg. When you're ready, please be seated. So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. As to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tipton.
What could happen to a loving father and a loving husband?
We're making line of police before they.
Search for the unspeakable on the internet.
Exposed body of the woman that you adore. Government suggests it was an affair. There's no proof of that. There's no proof that Brian Walshe knew anything about an affair between the woman he loved and William Tesler. Money? Second reason that the government suggests. Family money? Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of the 3 children. A motive? There's no evidence of that. Refusal to consider prison for a terrible mistake he made. The case that began in 2018. There's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up to, and something that he did. So, what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Brian Walshe? Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walshe was a loving father and a loving husband? We know from much of the testimony of Jim Motlow. We know from simple testimony from Julie Basler from KinderCare. When asked questions about her experience with Mr. Walshe and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walshe trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard and been presented that he ever once thought about harming the woman he loved. That he ever thought about harming the woman he loved. That he ever planned to harm. That he ever intended to harm. So, when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being afraid to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, and panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with her killing, because he never killed Brian Walshe. You will hear arguments that you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Brian Walshe. You can't base your verdict on anger to what Mr. Walshe did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. But that's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. He places himself before this country which you are, the obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Litlow's testimony, where for almost an hour he talked beautifully about the love between these two people. that he talked glowingly about Mr. Walshe. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem. And reflect upon the evidence that he gave of a phone call he had with Mr. Walshe on the 4th, when the conversation was confusing to Mr. Mutlow, confusing where he kept asking what could have happened that would result in Anna Walshe leaving. The lie that Mr. Walshe was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Mutlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walshe leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches. The dark, troubling evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. And the first one is, how do you dispose of a body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then the sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walshe began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walsh, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. You need to try to understand, what can I do? Then the searches become darker. They become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them. You'll read about them. And then you see searches that cover days. And there's searches about cleaning. And there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting, because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches, and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned to kill his wife? And that is the government's theory. He planned. He deliberately premeditated the plan to kill his wife. Where is the evidence of premeditation? In thousands of pages of records. I suggest to you respectfully, you are the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. Could I please have exhibit 201? And next, exhibit 202. And finally, exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will. But think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove that it has even blood on it. And they take it, and they should. And then, what happens is everybody loses interest in the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walsh killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down now. digital data. Talked about that briefly, but there is nothing in that data. All of that data. And we're talking about text messages. We're talking about backbook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation, or intent to kill, or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walshe went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag, but then was put into a compactor eventually, and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Celine from the DNA unit. They all consistently said cross-contamination or transfer. They used different terms, but they all agreed. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative, of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors, say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers of multiple bathrooms. Nothing found, meaning biological evidence that might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walshe, Brian Walshe, as adults, enjoyed their life together and had spent their life together, perhaps every night, before she moved to D.C. to take that job. How do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert. But he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have Exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood, that test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walshe attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it, Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Celine, the profile of those blood drops matched the profile of Anna Walshe. So to suggest that Mr. Walshe did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house, and that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of his wife and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet and be sure. If there is no evidence of any killing that happened, and there's no evidence that anything was done before Mrs. Walshe died, and there's no evidence of premeditation or anything, there is evidence of lying and disposing of the body. You can take that to one statement. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present to you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walshe had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. No, I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walshe because there was a promotion going on. It wasn't that Mr. Walshe said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance. But they don't tell you why. They just give it to you. They do the same thing with the searches. Remember when Trooper Keefe was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walsh, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing out pieces of evidence. Why? Why were you given... Why was Trooper Keefe asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I will encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate, premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here, thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walsh, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all those things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rug. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boot, and he felt it, and he said, felt like pieces of rug to me. Rug? That is in evidence. It has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walsh, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walsh? No. The evidence does not support a finding of premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walsh is talking to the police, and he says, I messenger. When asked about, and he was trying to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence. and suggest that there's evidence that Mr. Walsh had seen text messages between Anna Walshe and William Fastow. And those text messages between Anna Walshe and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walsh saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them. But ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence that Mr. Walsh ever saw any text message, because he was trying to say iMessenger, and now you know from the testimony of Trooper Keefe, there's no such thing as iMessenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walsh ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it then that on New Year's Eve, Anna Walsh is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walshe, as she and Jim Mutlow were taking photographs, hey, why don't we send a photograph to Will Fastow? And was there any evidence that he reacted, Mr. Walsh? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutlow really took efforts to remember, and then he said, oh yeah, that happened right before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walsh reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fastow, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, you know, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, Is it as unlikely? Is it bizarre? Because Anna Walshe worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A lay person that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe you. Context. I walked Trooper Keith through all of that information. Something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walshe and her husband, Brian Walshe, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keith never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in D.C., talking about all of that, and it's all in the text. Joking when Anna Walshe was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger. You buy me a Porsche. And then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want, that speaks once again to the financial issues that were non-existent? How does it go from that to someone who is purportedly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce? About 11 minutes of talking about divorce and searching about divorce in 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walshe and Anna Walshe in the days leading up to January 1st. So now we have come to just the evidence that once again just explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event. jovial, laughter, love, described in various terms, various ways, not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walshe cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine you are so in love. You support your wife to get a job in D.C. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name to protect it, because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walshe was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who wouldn't be? They were living apart. She wasn't seeing her children. Now, maybe, it's up to her. Anna Walshe was a wonderful person and a wonderful mother. And that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling a conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love him as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walshe was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing to her best friend, Alyssa Kirby. Could I have exhibit 169, please? We are now at the end of the New Year's Eve party, and they sign the champagne bottle. And we were talking about the feelings and the emotions and the state of mind of Anna Walshe and Brian Walshe, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. My fault. I'm sorry. Exhibit 257. And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walshe talking to her husband. Look what she says. What a year, and yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother wouldn't? But they were working toward the future. And one final thing. about the state of mind of Brian Walshe at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keefe about. A restaurant that's right on the line of Marblehead and Warren. Exhibit 59, at 12:27, those records indicate that Mr. Walshe credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And Exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, did Mr. Walshe lie to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize. Mr. Walshe loved Anna Walshe, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walshe. None whatsoever. Mr. Walshe is not guilty. He's not guilty of murder. Thank you.
Jurors can't. I want you to take a moment to stand up. Everyone good. When you're ready, you may be seated. Now we'll hear the closing argument of the Commonwealth. ADA, yes. You may proceed.
Thank you, Your Honor. Anna Walshe is dead. Anna Walshe is dead because he murdered her, and he intended her death. Anna Walshe is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to D.C. for a work emergency. There was no emergency. She didn't say goodbye to her son. That's just a story that the defendant told people. But since January 1st, Anna Walshe has not been seen by her friends or co-workers or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phones had no contact with the Verizon network since January 2nd, 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Bootloop left around 1:30 a.m. on New Year's Day. And after he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. And the photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cut-up pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fatsow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers had the DNA of Anna Walshe and the DNA of the defendant. Then there's the bathrobe. And there are 2 bloody white towels. A towel was tested and had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this because the defendant was researching cleaning. How to clean blood from what floors? Does the dishwasher clean blood? Is it possible to clean DNA off knives? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Vin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed. The parking lot is empty. He's not yet gone to Lowe's. On January 2nd of 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Walsh dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating from the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Semino, her bar instructor, told you about this exercise class that she took the morning of December 31st of 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastel told you that Anna was very active. They did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learned that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all yet. Peter Capozzoli told you that the defendant's mother had signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, her family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to avoid prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her, and Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought her plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving, and he mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always dealing with the boys.
Anna returned from Serbia in December, but she only spent one day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and the Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Fastow on his cell phone, the man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to be down. Anna quickly returned to D.C., and on December 27th, the defendant was looking up the best strategies to divorce for a man and the D.C. divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with General Wu and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's federal case. It was ongoing. It was getting to be too much. On December 29th, Anna went out with Alyssa Purdy, and she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in D.C., and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building. Looking up something that had happened in the spring of 2022 when Anna first started working for Tishman's Fire. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. Was planning the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in D.C. and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about a Porsche. He didn't want her to realize that he was aware of the relationship with Will or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Baston. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words, he was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives. But because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This is ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle Reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics show that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she went and put her phone upstairs after that?
After that, she, let's say it's 10 or 15, and then she I remember her putting her phone upstairs because then she came back down without it.
Was Thomas came down at one point and hung out with you?
Yes. Yeah, exactly.
Was this before, during, or after Thomas was participating as well?
Oh yeah, Thomas went to bed at he went to bed and then he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jem and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when that's when the photo was taken about. So it was maybe 10 o'clock or something like that.
You know where upstairs she put her phone at that point?
Yeah, on her bedstand.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting or a tie-back suit and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and a bag that he told police that she had, but she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters, disposing of her body in the trash. Chatham West apartment rental, the Claremont apartment rental. And police confirmed this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. Look at his mindset, look at his internet history. Want to get away with murder? Use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had a plan. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask, and he wore gloves, and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he didn't stop there. He went to CVS to buy hydrogen peroxide, and then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and handles. And then he went to Home Depot, where he had bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with a store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman's Fire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not panicked. The police were coming to the house and to talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Miss Jim. The defendant prevented anyone from ever finding Anna's body, and there was no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy without a body, and all that remains of Anna are a few hairs, some blood, and a few things that belong there. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her COVID card, and 2 other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing of Thomas' body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walshe. Thank you.
I will see counsel at the side of the bench. George, you're my guidepost. Do you need a break to the bathroom? Okay. All for one, one for all. Give you a break to the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
All rise, please. Jurors, follow me.
Seated. I will give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other 2 counts, and asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walshe that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I had told you that I was putting off the sentencing until we had a verdict on the charge of murder. But now that it's a Friday, and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the social. I
think there's a valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All rise.
Seated.
Stand up.
Running, Your Honor.
Yes, please. Just so it's on the record, everybody saw the small edit I made to the verdict slip, and everyone's fine with it. Is that right? Everyone's nodding. Thank you.
All rise to the court, please. Jurors entering. Court is back in session. You may be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate it. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the verdict slip, in ink. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walshe is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then your verdict must be not guilty. Let me talk about your role. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walshe's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence, and you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walsh did not testify in this case. You may not hold that against him. Mr. Walsh has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walsh did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walsh is guilty beyond a reasonable doubt. The fact that Mr. Walsh did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons, and in those types of cases, we allow a person with specialized training or experience, we call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions, on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion is not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 Forest Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during the deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements, of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, because they're not exhibits, and you won't be able to consider them. Other things that are not evidence and you may not consider when deciding this case are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, then neither the question nor the fact that the witness did not answer is evidence. If I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that I struck, not evidence, you may not consider it. Anything that you may have seen or heard when the court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorneys said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all of the evidence in the case. Some evidence proves a fact directly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence that, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable, and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself, did the testimony seem reasonable or probable? Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Anna Walshe allegedly made to William Fasto, Jem Lutlu, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walshe's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called consciousness of guilt. Spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest and that he may have taken steps to conceal Anna Walshe's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walshe after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether, in turn, such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution, and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walsh and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or, in essence, erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we've talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible, and that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note and a form that you all agree on. The court officers have. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom, and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the alternate jurors. We talked about those alternate jurors. The law permits only 12 jurors to participate in deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all of the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision-making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult with the attorneys. So I talked to you about a four-person, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the foreperson of this jury. Our clerk is now going to randomly select 4 of you from among all of the jurors except the foreperson to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138's number is coming out of the thank you, Madam Clerk.
Your Honor, numbers 1 through 16, with the exception of number 6 of this. Your Honor, our first alternate is a juror in seat number 12.
Grab me the notebook and just follow me.
Our next juror, our alternate is a juror in seat number 5. Juror in seat 15. And our last alternate, Your Honor, is juror in seat number 11.
One last substantive thing that I want to go over with you, jurors, before I really get into finally the concluding remarks, and that is I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023. And it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are 3 options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the foreperson in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in the court officers.
Please do solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they be. You shall not speak to them or suffer anyone else to speak to them except by order of the court or ask that they be and say
I will.
So now the deliberating jurors, the 12 of you, are going to go and start your private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict, dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all rise, please. Jurors, take your notebooks with you and follow me.
So I will, as I said to you at the side of the bench, there's some small edits necessary in fact. You may be seated. Some small edits that I need to make to the instructions, and I'll make those now, take the draft off, make sure the numbers are all right for the index that goes down with them. Anything else that the parties need to bring to my attention before I do that?
We received materials to secure those items, and we're going to work
Oh,
on
can I
that.
see that? Are they in secured yet, or you're going to secure?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, because I do want to take a look at those before they go in. And of course, our court staff, as well as court officers, want to take a look at those to make sure that they're comfortable with what's going into the jury room.
And we thought we'd cut up pieces of parchment paper for the jurors if they need to examine anything that they can place on their table.
You have a roll, they can do it themselves.
We have a roll. We can give them scissors if you want.
Well, cut them off.
That's why I put that out there.
All right.
Thank you, Your Honor.
I think you're pretty familiar that I have a 10-minute rule, which means at all times, Madam Clerk should be careful that you should be able to return to the court within 10 minutes. All right? I won't take a further between the hours of 1 and 2 on any day to get an opportunity to tend to your other work.
Thank you, Your Honor.
All rise.
Be seated. Court's in session.
Everybody saw the question?
Yes, Your Honor.
My suggestion is that there are 265 exhibits, and I ordinarily have sent in an exhibit list that the parties have reviewed, and I would think that would be an appropriate way to assist them in their evaluation of the evidence, but it needs to be cleaned up. In particular, on a quick review of it, photo 52 should say something other than butcher paper.
Yes. And 189?
Also the same term?
No.
What were you calling it? What kind of paper? Bench?
Bench paper.
That term is used throughout. So what is it that is, that term is used in other numbers? So is it something about that particular photo that is problematic with that description?
Oh, I just don't like it, but...
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper, and I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
That's correct, Judge.
Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
That's, other than that, that's the only...
Where's 189?
blood clots in it.
Oh, that is.
aside from that one suggestion to change.
Okay.
Should I see 182?
Oh, doing this one? 182.
All right, so I'm going to write back to the jurors, and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97, and here's an exhibit list to assist you.
Thank you, Your Honor.
Here you go, Madam Clerk. If you want to look at it, you're welcome to. It's pretty straightforward. Thank you.
Court's in recess.
was the Wild West.
Court's in session, may be seated.
Your Honor, we're back on the record in Commonwealth versus Walsh.
Thank you. As is my custom, at 4 o'clock, I send in a note on every day the jury's deliberating, asking if they want to stay until 4:30. That note will be marked as the next exhibit for identification. And it gives them the option of staying until 4:30 or suspending and coming back on Monday in this instance, and they've elected to do the latter. So we'll bring them in, send them on their way.
R for ID, so marked. Thank you.
All rise to the court. Jurors entering.
I'm gonna go see Mom, but otherwise I would. Maybe on Monday if we're.
Court is back in session. You may be seated.
Welcome back, jurors, to the courtroom. And thank you for your work today. And I'm going to send you on your way for the weekend. I remind you, jurors, that the rules still apply. They will apply until you reach your unanimous verdict. I remind you of those rules now, jurors. Don't speak to anyone about this case. Don't do any research about this case. Continue to have open minds as you evaluate the case and as you wait to see if you are going to evaluate the case. Don't access any social media or any news media over the weekend. Hope you have a good weekend, get some rest, and we'll see you back here ready to work on Monday morning. Thank you, jurors. Thank you.
All rise to the court, please. Jurors, follow me.
Thank you.
May be seated.
Just as short as council, make sure you're back here a few minutes before 9 o'clock in the morning on Monday. Have a nice weekend.
Thank you.